we're here today mostly to discuss the GDPR, and it's a new enforcement mechanism. I'm sure you've covered all of its main aspects and its possibilities and the expectations that it will lead to a greater level of data protection. However, there is something underlying the GDPR and the currently enforced directive on data protection, which cannot really be solved by data protection law, which is the following. Data protection law assumes that when consumers are presented with processing, they actually have alternatives in the market. You can see this in the way that consent is a legal basis for processing. You can see that in the new right to data portability. And this derives from the fact that the data protection legislation seeks to balance the interests of the data subject and of the controller, basically of the consumers and of the companies. What does this mean? This means that because there's a balance of interests, some amount of control is put into the hands of the data subject to assess how far is he or she willing to go in relinquishing control of his or her data. The problem is that often that alternative, that market alternative, is not present. It's been well observed by economists that digital markets tend to concentrate. Digital markets tend to be highly dependent on, I won't bore you, on network effects. These kind of services tend to have a lot of stickiness, meaning people have difficulties in leaving the services, and digital markets also tend to work with dynamic competition. Sometimes new services come along and they substitute the old services without actually having real competition as other goods and services with several players in the market. This raises the question, are these markets working correctly? Is there something that we can do at the level of controlling market power or on the level of consumer choice? Is there room for competition law? As you know, in 2014, the European Data Protection Supervisor went into this breach and came out with a really almost revolutionary opinion where this was the opening image of the opinion, and you can see the idea. We have these three areas of law, and there's an overlap. There's an overlap there in the middle in relation to consumer welfare. And what are the practical implications of this view? Well, the DPS put forward the hypothesis of what if consumer welfare included data protection concerns. Now, this is important because consumer welfare is the guideline of the application of competition law by the European Commission. They have said that consumer welfare is their priority, and they will analyze the cases that they will pursue based on the impact of consumer welfare. So the EDPS said, well, if consumer welfare could be understood as including data protection, we could do many things. For example, when a merger is notified to the European Commission, and I don't know if you're aware, but any merger, any acquisition between companies that have any sort of dimension at the European level has to be pre-notified to the Commission, and the Commission has to approve it. So if all of these mergers that went through the desk of the European Commission were controlled for their impact on data subjects, this would be huge. If you well remember, there were a lot of privacy concerns raised in Facebook, WhatsApp, and all of these major companies are constantly acquiring other companies. If these mergers were controlled for their effects on data subjects, and it could revolutionize, basically revolutionize the application of data protection law.